Hi there, my name is Ron Wright. I'm a professor of law at Wake Forest University. We're going to talk today about a criminal procedure topic. It relates to something called stop and frisk. You might have seen this on television, in the movies. You might have seen it beside the road as you're driving. You might have been involved with it yourself. At some point, a police officer is talking to someone, and then he says, "You're stopping right here. You're not going anywhere. I'm going to insist. And I'm going to check you for weapons. I'm going to pat you, frisk you for weapons." In that setting, there are legal rules that apply to what the officer can do. Those legal rules go back to a famous case called Terry versus Ohio from 1968. So our topic today is going to be the basics of that Terry decision. Let's go and talk about Terry basics. Okay, folks, let's get started. We're going to be talking about the legal framework that applies to stops and frisks. This is a really important moment in criminal procedure. It's the front gate, really. There are lots of things that police officers do that really don't count as criminal procedure. So I drive my car around, I look out the window of the cruiser, I get out and walk around, I'm the cop on the beat, I talk to people, I notice things that are out in the open. None of that is criminal procedure. I mean, the law of criminal procedure really doesn't address any of that. But when a police officer gets suspicious about somebody and says, "You, stay right there, don't go anywhere," once you exercise that authority of the state to control somebody's movement, that becomes criminal procedure. That's where the law starts having something to say to the police officer. And similarly, if the officer says, "Before we talk anymore, I'm going to check you for weapons," and pats the suspect for weapons, again, criminal procedure has something to say about that. So we're going to talk about the legal framework that applies to this entry point, the first interaction between citizen and police that counts as criminal procedure. The whole thing starts with Terry versus Ohio from 1968. I want you to picture this like an old black and white movie with stars with fedoras on and trench coats and old cars running around. And it's Cleveland, 1963, on this very intersection at the corner of Euclid and Huron. So that's Huron heading off diagonally to the left and Euclid heading straight up the picture. It's Officer Martin McFadden walking around. Officer McFadden is a 39-year veteran of the force. He's been a detective looking for pickpockets in downtown Cleveland near all the department stores and the men's clothing stores and women's clothing stores and drug stores and so forth. He watches for pickpockets. He's walking along and he notices these guys standing right at the corner of Euclid and Huron. And they're talking to each other, and at first he doesn't notice anything, but then one of them walks down the street, walks down Huron, and starts looking in a particular window. He can't tell whether it's the Diamond Store or United Airlines, but it's up about 400 feet ahead of him, and he says, He walked in and really took a close look in there, walked past it, turned around, walked again back past the store, looked in again, went back to the corner and conferred with his friend. He says, "This looks a little weird," and so he kind of goes off into another store and is watching from inside the store so that they can't see him. And the other guy goes down the street, looks in the same window, goes further, turns around, comes back, looks in the window. Each of them does this like 4 or 5 times. He says, "They are casing the joint for a robbery." It's good 1940s movie talk, right? Casing the joint. But at any rate, he thinks they're preparing for a robbery and they're looking, to see what's inside. So he decides something suspicious is going on. Then this third guy, Katz, comes in, Carl Katz. And he starts talking to the first two who were there. Later we learned they are Richard Chilton and John Terry. And so the three of them are conferring on the corner, and then Katz goes on around the corner over onto Euclid. But the two original guys, Chilton and Terry, stay there, and again they do a couple of walks past the store, and then they go around the corner and head up the street on Euclid, and they end up stopping at right in front of a men's clothing store called Zucker's. 1200 Euclid. And so Officer McFadden comes out from his hiding place and walks around and finds them, and he walks up to them after another 2 minutes or so of watching them, talk in front of the men's clothing store. And he says, "Hello, I'm a police officer. What's your name?" All three of them mumble something, and he says, "Okay, stand in front of the plate glass window there, the display window for the store." And so while they're outside, Officer McFadden says, "Look, you, the guy on the right," there are three in a row, 1, 2, 3. And so he says, "You, the guy on the right," and he spins him around physically. Terry is facing him, but he takes Terry by the shoulders and spins him around, and then he pats the outside of his overcoat, and he notices, "Oh, I just hit something that I think is a gun. I'm going to get that gun." And so he tries to reach in. It's in the left pocket, but it's an inside pocket, and he can't get to it, and it's sort of stuck there. And so he ends up pulling the jacket off of John Terry, and he says, "Okay, guys, all of you in the store, and keep your hands out of your pockets." So he orders them into the store. They all three walk in. He says, "Up against the wall there." So they all stand there, and he says, "Keep your hands up." So they've all got their hands up. And now he goes along, and at this point he can feel in the pocket of John Terry's coat, his overcoat, and he finds there's a handgun there. There's a .38 caliber firearm. And then he pats the outer clothing of Chilton, and he feels another gun, and he's able to reach into the outer pocket of the trench coat or the overcoat for Richard Chilton and pulls out another gun. And then he pats down Carl Katz, and he finds no weapons on Katz. He then checks the guns and notices that they're both loaded. He says to the store owners, "Call the police, bring the paddy wagon down here. These guys are under arrest for carrying a concealed weapon," which is illegal at that point under Ohio law. So Officer McFadden has found his suspects, and he has made an arrest. What's going to happen now? Well, these suspects are charged with carrying a concealed weapon. The government's going to try to put in the evidence that Officer McFadden found, but the defense says, "Hold it. You violated the law by searching my clients that way, and so you can't bring in that evidence." So there's a pretrial motion to suppress. The trial judge denies the motion and allows the evidence to come in. There's a conviction of both Terry and Chilton on these charges, and at that point, we've got an appeal to the Supreme Court. What are the arguments of the parties once they get to the Supreme Court? Well, first of all, there's John Terry's argument. It's a good old-fashioned argument. It's the classic doctrine at the time, and it says there are two levels here. At one level, the police aren't doing anything at all that criminal procedure can address. There's no regulation. If we're just talking, looking at something that's in plain view, if I'm not doing something that counts as a search or as a seizure, then I don't have to justify it in any way. There's no real legal regulation that's relevant. On the other hand, once it becomes a search or a seizure, then you got to show probable cause. You got to show some serious reason to believe that wrongdoing has happened. And so John Terry says, we've been doing this for decades and decades in the federal system anyway, and we know what probable cause looks like, and Officer McFadden did not have probable cause. So easy case, we win. This was plainly a search. It was, you're stopped, so it's a seizure, and it's a search because he's touching the bodies, the outer clothing of the suspects, and he doesn't have probable cause to support it. So we've moved from the lowest level of no regulation at all up to that top level of probable cause, and the government can't satisfy its burden up on that top level. So that's Terry's argument. Good old-fashioned doctrine. The state of Ohio wants something that is in between. They say, we're not so happy with just a two-tier requirement. So note, it pays to be creative. If the law is not favoring you, come up with a reason for an innovation, a slight variation on the current law. Not a huge change, but something incremental can win the day in a common law fashion. So Ohio asks for something in between. They say, okay, this isn't nothing. It's true, he's touching them and there's a search going on. But it's also true that this isn't a full search, like empty your pockets and put your hands behind your back and you're under arrest. I mean, at least at first, when he was just saying stay there, this was something less than a full search, something less than a full arrest seizure. And for that reason, we ought to be able to justify it based on something in between, not full-blown probable cause, but that in-between level that we now call reasonable suspicion. Some lesser showing, and that, they say, Officer McFadden had. He had enough to establish reasonable suspicion that some kind of wrongdoing was going on, that they were planning a robbery. The Supreme Court buys it. And they say, yeah, we now believe that there is that intermediate category, and this stop and this frisk was justified based on reasonable suspicion. But reasonable suspicion of what? And here's where the holding gets interesting. You actually have to have reasonable suspicion of two different facts. So first of all, you have to have reasonable suspicion that criminal activity may be afoot. That is, this person either has recently committed a crime or is about to commit a crime. I'm not sure of it. I couldn't prove it in court yet. I'm still gathering the evidence. But I have a reasonable suspicion that you're involved in a crime. And separately, I have reasonable suspicion to believe that you're armed and dangerous. So you make those two separate showings. Notice from the court's opinion in Part 3, it's talking mostly about that second form of reasonable suspicion. So it says that it's not going to be enough to have an inchoate and unparticularized suspicion or hunch. You've got to have some kind of specific reasonable inferences in light of the officer's experience. But in Part 5, it's very clear that there are two different showings of probable cause. First, that criminal activity may be afoot, and that the person involved here is armed and dangerous. That's what you need to show to justify this stop and frisk. Let's imagine a different outcome. What if the Supreme Court had ruled otherwise? Can we imagine it? Well, first of all, let's think about whether frisks even existed up until the time that the Supreme Court blessed them in 1968 and said frisks are legal and they're okay if they're supported by these two forms of reasonable suspicion. Did frisks exist? It's pretty clear they did. I mean, the newspaper in Cleveland, the Cleveland Plain Dealer, I always love that name, the Cleveland Plain Dealer went to Officer McFadden in 1967 before the case and said, hey, McFadden, what do you think about the Supreme Court considering your case? He says, well, I sure do hope they approve it because frisking is what police officers do. I don't think we could do the job without this. It's just always been a part of what we do as police officers. So it existed in Cleveland, certainly, and you see lots of other newspaper indications that this was just a common part of policing. So the Supreme Court was, for the first time in 1968, ruling on the legality of something that police officers had done for decades and decades, really generations, going back to the start of policing. Why did they wait so late? Probably because the Fourth Amendment did not apply to the states until, 1961, Mapp versus Ohio, and this is 1968, so only 7 years later. So if you think about it, this Fourth Amendment doctrine really had not been relevant to state enforcement until just a few years before this case came out. So I think that's probably the number one reason. It may also have something to do with the growing prevalence of handguns and a few other factors. By the way, speaking of prevalence of handguns, think about how complicated the reasonable suspicion standard becomes in a world where you've got you very commonly encounter carrying concealed weapons laws or CCW laws that make it legal to carry a weapon. Now it's very important to distinguish between whether I've got reasonable suspicion of a criminal activity. Carrying the gun can't count there. It's got to be something else that you're doing that's illegal, versus reasonable suspicion to believe that the person has a gun. At any rate, can you imagine an alternative? Well, Justice Douglas, pictured here on the right in the slide, William O. Douglas, he says, this whole three-tiered innovation that Ohio wants us to do, it's dangerous. It's an innovation. It can be too easily manipulated. I'd rather stick with a nice, good old-fashioned two categories that can't be, tinkered around with. Whereas, Chief Justice Warren, Earl Warren, pictured here on the left, says, well, this is really just a reasonable response to the real safety needs of the officers. We really can't imagine ruling otherwise because they're gonna do what they have to do to keep themselves physically safe. So it's kind of an accommodation to reality. I think in the end, Justice Douglas was wrong. You've probably heard me say those words before. When Justice Douglas swings for something, he goes for the fences, and when he's right, he's very, very right, and when he's wrong, he's very, very wrong. But in this case, I think he's wrong. I think it's just as easy to manipulate 3 categories as 2. In fact, if the court had not created that 3rd category, I predict that I anticipate that the court would have started expanding what counts for probable cause and would have watered down that standard. At any rate, that's the ruling of the court and the majority opinion from Chief Justice Warren. So we've got a couple of application questions now. Now that you know the basics of the holding and the factual background of the case, how does it go forward from that point forward? Well, one big question is the question of categorical frisks. Put it this way, does the judge in the trial court require individualized reasonable suspicion from the officer in every case to show that this particular person had a weapon or was armed and dangerous? Typically, when law enforcement officers are trained, they are trained to look for certain signs of a person being armed. So you would look for, a bulge in the pocket at a place where a holster might be, or a bulge in the, in the waistband where you might keep a gun. But remember, it's not just guns that you could be looking for. You could be looking for knives or other smaller weapons. So it's not always going to be, an obvious, from the outside, from the outer clothing. Another thing that officers are trained to look for is if the officer comes up and the person sort of turns sideways and is trying to shield the view of one side of their body. Maybe there's a gun over on this side, on the side that they're trying to shield from the officer. So standing in an odd angle once the officer approaches is thought to be one indication that the person might be armed. But could the officer go further than that and say, well, it's not so much that I saw a bulge in the clothing or I saw a knife handle or a gun handle sticking out of a waistband, or that they were standing in an odd angle. Instead, it's the fact that I'm investigating this person for drug distribution. And drug dealers, we know, very often have guns. And so it's the fact of drug distribution as a category that gives me this reasonable suspicion. In other words, everything in that box, everything in that category counts not only as reasonable suspicion of the crime, but necessarily reasonable suspicion that this person is armed and dangerous. There are a few courts that have been willing to say that. There's something of a mess in the lower courts on this question of whether the crime itself can count in that separate showing of reasonable suspicion that the person is armed and dangerous. One other thing that is very interesting in application of this case is that we're starting to see something more than just the legal requirements being met for individual cases, one case at a time. So sure, you can come into court and the defendant will say, keep that evidence out, Fourth Amendment, and the government will say, yes, but we can use the evidence because reasonable suspicion that a crime's been committed, and second, reasonable suspicion that the person was armed and dangerous. The frisk was limited to the outer clothing, very limited intrusion, therefore middle tier category, we're all good to go. Yes, you can meet the requirements in one case, but what happens when you start looking at the entire pattern of cases and you start noticing, wow, every time a minority citizen of this city walks out, they're getting stopped and frisked. And pretty much everybody who's getting stopped and frisked is a racial minority. Does that create a problem? Could be a legal problem. It's become the basis for litigation in a number of cities. New York City is one example that lasts really over decades. There's a long-standing series of litigation over the pattern of uses of stops and frisks in various places. What's really interesting about this litigation in the cities about the pattern of the use of stop and frisk is that very often they don't result in an appellate court ruling saying, yes, this is an equal protection violation and you must stop, here's the injunction. It's not so much that, it's that the case settles. The parties agree, look, we'll agree not to go forward, and the government will agree to collect statistics. We'll keep closer track of how these things happen, and we'll post it on the internet, and everybody can analyze this and see how it's working or not working. And it's that data that has been the key to what happens with stop and frisk since then. So a number of different cities, either because of litigation that forces them to agree to collect the data, or just because their citizens say, hey, Chicago, listen, New York is keeping their stats, why don't you keep stats as well? So by comparison to other cities, a lot of cities are starting to keep the data and then post it online, and people are starting to analyze it. And on that basis, you can get pie charts like the one that's shown here that breaks down the number of stops by the race of the person stopped, and you can compare that to the racial makeup of the city and see whether there's some big gap. And in some places, there is no particular difference, but in others, there is. What's really interesting in the New York data is that that Latinos and blacks are stopped somewhat more frequently than whites or Asian groups. But what's really interesting is that among the pool that are stopped, the number of blacks and Latinos who are frisked in addition to the stop is enormously higher than the number of white suspects who are frisked. But at any rate, the data allow you to start seeing patterns like that. And people in one city can start saying, how come our city looks so much different from other cities? So people in Chicago would say, how come, you're stopping 1,000 or 93.6 people per 1,000 in our city, and in New York, they're way down at 1.6 at one point, or maybe up to 20, but nothing near 90. I mean, Chicago police, what's going on here? How come you've got to use stops so much here? It's not that it's the basis for a court case, it's the basis for a political conversation. It means that the police start saying, look, we recognize that we are here to, serve, and that if you are experiencing this as harassment rather than us making your community safer, then we need to do something differently. And so the statistics end up driving a new political conversation about how the police are going to carry out their job and maintain the trust of the community. So what I want you to notice here finally is the progression of legal sources. You start with the Fourth Amendment, dealing with one case, evidence coming in for one case, did you meet the rules or not, reasonable suspicion, two kinds, etc. But then when you go from Fourth Amendment to equal protection challenges, from equal protection challenges out to data being collected, and all of a sudden now city councils are involved and state legislatures that are making them collect the data and paying for the data collection. And then you got community groups talking about what kind of policing we want and how many stops are acceptable and when do we feel harassed versus protected. So you broaden the conversation as you move out from Fourth Amendment doctrine to everybody talking about stops and frisks. Just like I say all the time, if you're only looking at the judges, you're missing a big part of the story. Okay, so we're done with the basics of Terry. For next time, we're going to talk about the scope of a search and whether it extends to smells and to something that you can feel immediately from the outside of the clothing, something called the plain feel doctrine. So we'll be talking about that next time. We'll get together then.
Hi YouTube, my name is Christopher Lachey of C.W. Lachey Law. I'm an attorney here in North Carolina, and what you're about to watch is a presentation done at a town hall on Second Amendment rights in North Carolina, as well as certain federal laws. Terry Stop and Frisk. So Terry Stop and Frisk, or Terry Stop, Terry Frisk, is based out of Ohio law, and it went to the Supreme Court. So in a Terry Stop, Terry Frisk, an officer will approach an individual and he will begin questioning this individual. He will do a pat down of the person, their outside clothes, and what the officer is doing is feeling for weapons. This was a bad PR move in New York because even though a lot of weapons were recovered from repeat offenders, it was being used to target minorities. You don't have any requirement if an officer approaches you to engage that officer in conversation. You can ask him, am I being detained? No, you're not being detained. Bye. Walk away. You don't have to talk to him. It's not required. If you have a pistol on you, if you got your CCW, and an officer walks up to you and says, hey, can I talk to you for a second? Nope. I don't want to talk to you. If he says, get back here, you're being detained, okay, you have to stop. You don't have to tell him that you have a firearm on you. That's not required. Now, when he finds it on you, he's going to ask for your CCW. He's going to say, why were you concealing a firearm? Well, here's my CCW. That's the extent of that conversation. That's as far as it has to go. The less you say to law enforcement in that situation, the better, because everything that you say can and will be used against you in a court of law. So how does an officer determine whether they're going to stop somebody? So an officer may briefly detain a person they reasonably suspect is involved in criminal activity. So an officer has to first get a call or an alert or something. White male, early 30s, 6.5 feet tall, hanging out in the park. And you happen to fit that description. The officer has the reasonable suspicion to briefly detain you. But that gets challenged in court all the time. The officer is going to be asked, what did you hear that made you think you needed to stop this person? Okay, I talked about it at the station. We got reports that there was someone hanging out in parks. Okay. The Terry stop involves a limited search of the suspect's outer garments for weapons if they have a reasonable and articulable suspicion that the person may be armed and dangerous. That's the second part, and where this usually fails. An officer has to do a cursory check of the outside clothing. So if I've got something in my pocket that definitely doesn't feel like a weapon, the officer has to move on. It could be a baggie of cocaine. If the officer squeezes the baggie and says, oh, that's cocaine, he's violated your Fourth Amendment rights, and you can get that thrown out. You'll need a good attorney, but it can be thrown out. It's happened before. Thank you for watching. If you enjoyed this video and found it informative, like and subscribe. Go ahead and follow me on Twitter. You can also get my contact information in the description below. My firm is also on Facebook. There are many more video talks to come in the future, so stay tuned.
I hope this finds you well. Ever heard the phrase stop and frisk or Terry stop? Well, the case today is where it comes from. A Terry stop allows law enforcement to stop an individual and frisk them for weapons without probable cause. Today's case is Terry versus Ohio, decided in 1968. Here are the facts. A detective in Cleveland was patrolling downtown when he noticed two men, Terry and Chilton. The two kept walking back and forth between one particular store and a corner where they would confer. A third man was also seen by Officer McFadden on one of the meeting occasions. McFadden, believing the men were casing the joint, approached them and asked for their IDs. The men began to be evasive. McFadden decided to spin Terry against the wall and pat him down. He felt what seemed to be a gun and ordered the men into the store. The pat down of Terry was on his outer garments only. In the store, McFadden took a revolver out of Terry's coat and found another gun in the coat of one of the other men. They were both charged with carrying a concealed weapon. The court had to decide whether police can stop and frisk an individual they suspect to be armed and dangerous without probable cause to arrest. The court ended up holding that under the Fourth Amendment of the United States Constitution, a police officer may stop a suspect on the street and frisk them without probable cause to arrest if the officer has a reasonable suspicion that the person has committed or is committing or is about to commit a crime and has a reasonable belief that that person may be armed and presently dangerous. The court had to balance the protection of the Fourth Amendment against the danger to the public or bystanders or cops themselves. Remember, the Fourth Amendment protects a person from unreasonable searches and seizures. Here, there is both a seizure, which is the stop, and a search, which is the frisk. The court called a stop and frisk minimally intrusive, and the officer is allowed to conduct the stop and frisk as long as that officer suspects objectively that the person is armed and dangerous. Justice Douglas disagreed with the court and dissented, arguing that nothing less than probable cause can justify forcible detention of a person. My personal opinion is I agree with Justice Douglas. I think that probable cause should be required for every kind of stop. Again, my personal opinion, stop and frisk has taken a sinister approach in that individuals' liberties are routinely infringed upon through the use of stop and frisk. So you're probably wondering, where are they now? Well, unfortunately, I couldn't find any credible information on Terry. I did find a number of reports that reported him as being convicted of a sex crime years later. But I can't say that these reports are credible just because his name is so very common.